Hi, I'm Emma Kenno-Gallagher from Newburn Ellis, and today I'll be speaking to you about the co-ownership of IP rights, the Complexities Unravelled. So we'll be focusing on how co-ownership comes about, how it operates in law, in particular how various pieces of legislation automatically apply to govern and manage co-ownership agreements and situations. Finally, once we have a bit of a foundation in how the statute works to regulate co-ownership, I will then spend a few slides explaining why it's preferable for co-owners to enter express terms with their co-owning partners rather than relying on the one-size-fits-all model provided by legislation. So the first of the intellectual property rights that we'll be looking at is copyright. So how do copyright co-ownership scenarios arise? How do you end up with a piece of literary copyright or a musical composition or a logo design that belongs to two or more authors, musicians, or artists? Now, the starting point for determining ownership of a copyright work, whether it's co-owned or not, is that the author is always the first owner. Unless, of course, the author is an employee and the work was created by that employee in the course of their employment. In those cases, unless there is a separate agreement between the employer and the employee to the contrary, then the employer will be the first owner of the copyright in the work. This can get a little complicated where there is a disagreement as to what extent the employee's efforts on the copyright work were in fact carried out in the course of their employment or outside of it, but we won't go into that level of detail in today's webinar.